three bills on for hearing this afternoon. The first bill is Bill 1633, introduced by Senator Tina Rose Munya-Barnes. I'll read the statement, and then we'll... The bill is an act to amend Public Law 32-207 relative to repayment of funds to the Tourist Attraction Fund. And the sponsor statement, written by Senator Barnes, who's currently off island. Buenas and Hafide Todos Santos. This bill is fairly simple. The repayment of the Tourist Attraction Fund loan that was made pursuant to Public Law 32-207 will be repaid within one fiscal year rather than three. The primary impetus behind this measure is the Festival of the Pacific Arts FestPAC, which we will be hosting in 2016. Part of being able to successfully host this event on the scale befitting its importance is adequate funding. Over the last several years, funding for FestPAC has come from the Tourist Attraction Fund, but the amount remitted thus far to the FestPAC trust account is inadequate. Public statements by administration officials can be summed up as, quote, "Our finances are great," end of quote. This being the case, the cash flow of the government of Guam should be sufficient to repay the TAF, so the funds can be placed in the FestPAC trust account. Thank you for your input on this measure. We only have one person here to testify, and that's former Senator Tello Taitigui. Congratulations on your new position as Acting General Manager at GBB. Please.
Buenas and Hafide, Senators. Hafide Senator Chairman Vice Speaker Cruz, members of the Committee on Appropriation and Adjudication, Senator Morrison, Senator Ada, Senator Uggan, and Senator Snicklis. Good afternoon. My name is Tello Taitigui. I'm the Acting General Manager of the Guam Visitors Bureau. On behalf of GBB's Board of Directors and General Manager, Nathan Tonight, we thank you for the opportunity to provide testimony on Bill 1633, an act to amend Public Law 32-207 relative to the repayment of the funds to the Tourist Attraction Fund. The Guam Visitors Bureau fully supports Bill 1633, which repays funds borrowed from the Tourist Attraction Fund. For FY15, GVB did not receive a full request for capital improvements and safety projects. With the funding being placed back into the TAF, we respectfully ask that the funding be given to GVB to support these improvements and increase the safety of our visitors. Some of the projects not funded in the FY 2015 includes San Vitor's hardscape maintenance to include removal of graffiti and illegal banners, sidewalk safety and lighting improvement along Fahrenholt Avenue, multilingual crosswalk signs, Kmart lighting and crosswalk improvements, renovate and repair JFK Koban. For these reasons, we humbly request the passage of this legislation, which will enhance the visitor experience of our island and move closer to our Tourism 2020 goals. Thank you for the opportunity to provide testimony that supports Bill 1633. Sidusmasi.
Thank you very much, Senator. Any of the colleagues have any questions?
Thank you, Mr. Chair. Just a quick question. So the bill basically is going to reduce, we had a timeline of repayment that was originally 3 years. And so now we're asking to make it be a timeline of repayment of only 1 year. And so if it's going to be only 1 year, that basically means that we're going to look to repay this $4 million balance in this coming fiscal year, FY 2016. That'll be within the 12 months.
Yes, I believe that's what the bill states.
So do you know if the $4 million was included in the governor's budget transmittal, that he reduced his allocations by $4 million to include a repayment to GVB?
No, I don't.
Okay. That would be my only question, because if that was included, then I guess, we can say that it's already been factored in. But if it hasn't, then the question becomes, if we are going to pay back the $4 million in 1 year, where are we going to take it from if it hasn't already been itemized? So you're not aware if it's been itemized yet?
Not at this time,
okay.
No. I haven't had an opportunity to look at the executive budget.
Okay. Thank you, Mr. Chairman.
Thank you.
The next bill on the agenda is Bill 22-33, an act to authorize the transfer of the sum of $500,000 from fiscal year 2015 appropriations to comply with the United States District Court of Guam order dated January 16, 2015 in civil case number 91-00020, and to require that the Director of the Department of Corrections to report to the Speaker of Legislature in Guahan on matters relative to civil case number 91-00020. We have present with us to testify General Elizabeth Barrett Anderson. Congratulations, ma'am, on your new position. Director Joseph Augustine. And Mr. Ogden, will you be testifying? And you're just here, all right. And Ms. Focus from the Office of the Attorney General. Will you be starting off, General?
Yes, I think there it is. All right, thank you. Good afternoon, Mr. Chair and members of the 33rd Guam Legislature, and congratulations to all of you as well. Mr. Chair, as you've noticed, I don't have written testimony, and I believe that there is a 10-day window period, and I'd like the opportunity to provide written testimony as we continue on our work with the 2015 Settlement Agreement Working Group. This is an example of the binder that we have given to the Intergovernmental Working Group involving not only the Department of Corrections in my office, but the Department of Guam Behavioral, the Guam Memorial Hospital, the Department of Public Health and Social Services, the Guam Fire Department, DOA General Services Administration, and all the ships at sea who can help with the resolution of this 1991 settlement agreement that I signed 20 plus years ago. I come back 20 years later, and I am committed to take the revised agreement, settlement agreement that was signed on January 16th through to completion. The current agreement of January 16th, 2015 focuses predominantly 90% on issues of health and mental health, as well as oral health. A small 10%, and actually just one paragraph, refers to the issue of facilities, which is the locking system and some other facility matters that we have in our tour last Friday of DOC. Facilities matter related to the infirmary, where the physicians work right now. As we speak, I believe the Department of Public Works is actually doing a walkthrough again with the director's staff regarding the electronics, the electrical, and the facilities requirements. We'll get an idea on Friday from the facilities group, DPW, DOC, what will be the cost to repair, as the judge says. I'm sorry, maybe I just better step back. The Judge Munson, in his order, indicated repair. Didn't say build a brand new locking system. There are 4 units, as the director will testify to. They are all electronic or electrical, and we'll hear by Friday, and senators, you're all welcome. Please, don't hesitate to come to the meetings. I know Senator Uggan has asked to be on the list server. Once I develop a list server, we'll get you on that. Please do come, just to keep you informed of what's happening. We should have an idea of the cost for the locking system and the infirmary facilities. We have one idea that was developed maybe about a year ago, that to get our infirmary up to a workable condition with ceiling tiles, etc., maybe about $35,000. So that's just an initial. But if we can get that down by Public Works doing all the work, we can cut that down by half. The predominant and the more difficult portion of the current settlement agreement is medical, psychological, mental health, medical, and oral. And I think when I read the consent decree, the settlement order, a couple of days after it had been signed by Judge Munson, I was overwhelmed. Senators, do you all have a copy of the order from the judge? Do you, who does not? Senator Morrison, you don't, Senator? Could I just ask the staff to make you a copy? Okay. There are 35 points in the order. 34 refer to health, and just the one to facilities and the locking system. And as I read them, I became overwhelmed. And I think if you read them, you become overwhelmed. But then when you break it down inch by inch, and when I got further information from the director and Dr. Saad and Dr. Pat Timinglow, those are the two physicians. I'm one physician and a clinical psychologist at DOC. I started to think, well, maybe it's not as overwhelming as I'm reading. And perhaps the reason why it is not as overwhelming is because the department has been working hard in 20 years to establish policies and procedures for medical and mental health consistent with the National Commission on Corrections and Healthcare. We don't have in front of us right now the binder of policies and procedures. Some of what Attorney Focus and I have looked at complies with the NCCHC. You can read them and they're almost identical. So the work that DOC has done over the last several years is to write policies and procedures, as the order of the judge says, consistent with the National Commission on Corrections Health Care. So that was good news. We have policies and we have procedures. The Vice Speaker at the meeting yesterday suggested that we don't have to reinvent the wheel, and he's absolutely correct. Our nation, for the last 40 years since Attica, that 50 years maybe since Attica, some of you weren't born during the Attica years, the nation and every prison institution, whether federal or state, has had to deal with the issue of the constitutional rights of inmates and detainees. It's not anything new. And the National Institute of Corrections and the National Commission on Corrections and Healthcare, likewise, they've been around for the last 40, maybe 30 years. We don't have to invent this. We just have to make sure we're able to comply with it. And that's the tough job of this working group. The policies and procedures, I think, is the easiest part. The word in every paragraph that you'll get a copy of in the order is implement, implement, implement. And that to me is synonymous with money. You can't implement without money. The working group, therefore, seeks to put a dollar amount to each area of implementation. Whether that implementation means we have to buy medicine, we have to hire nurses, we have to train guards in the train new guards that can work in infirmaries. Whether or not we need to consider, as a territory, do we want DOC to have a pharmacy or not? If DOC is authorized to develop a pharmacy, as GMH and Guam behavioral, then they'd have to have a pharmacist. So the implementation factor on all of these, it's not just the policies and procedures, but what will the Department of Corrections need to implement, for example, procedures in the event of an inmate death or suicide, suicide prevention, intoxication and withdrawal. The DWI court has placed a great strain on the Department of Corrections when the DWI court, along with the administration, executive branch, decided to book and confine. You get arrested, you get confined. Within 48 hours, you might get released. Within 24 hours of magistrate, you might get released. But in the long run, if it's your first offender, you're going to have to go back for the remaining 48 hours. If it's second offender, you got 7 days up there. So, and I'll tell you, I have heard from DOC when, as the DWI judge, I have sent people up there for your 2 days in jail or 1 extra day, and they walk in there intoxicated. And I've told DOC, don't accept them. Don't accept them, they're intoxicated. So, what does it take for to implement intoxication and withdrawal procedures? Chronic care, oral care, seclusion and restraint. That is my goal and mission in order to provide the legislature and the governor an idea of what it's going to cost to implement. Because my goal and objective, and I know it is the goal and objective of the Vice Speaker, that we need to complete this. And if we don't, we are a short distance away, senators, from the cliff of receivership again. And we are still paying so much for the current 2 receiverships. I cannot see the territory of Guam going down that cliff again of another receivership. There are states, many states, that are into this. California has been on a receivership with regard to its medical and mental health issues since 2006, and there's no end in sight. But I have to tell you, they've been doing a marvelous job. Well, why can't we do a marvelous job? The working group has nothing to do with, and I am not considering many, many, many other issues, such as building a prison, and a plethora of other issues that the Director of Corrections faces on a day-in, day-out basis. That is the work of the Lieutenant Governor's Blue Ribbon Commission. Of course, his Blue Ribbon Commission and the working group are one and the same. We have the same folks on both sides. But every time an issue that comes up, and it does come up almost every meeting, well, we need to look at, for example, there was a request, we need to look at Unit 2 and 5, or no, 2 and something else.
5, 6, 7, 7.
There were 2 other units, 2 or 3 and 4. And I said, whoa, that's not in here. So my focus, it has to be narrow to this, because my objective is to present to Judge Munson that we have accomplished this, to motion to dissolve the agreement and to request him to dismiss the case. But I think one of the greatest supplements to the work that we're going to do is for the director to put together a master plan, a strategic plan, whatever flavor you want to call it. A plan where we seek the assistance of the National Institute of Corrections. They just say, you want help from us? Write to us. Ask us. And they have grant money to do that. So I'm working with the director, and I will, on behalf of the director, write to the National Institute of Corrections. We need to build a master plan. We need to build a plan, and we need to build it fast. Because if I were Judge Munson, I'd say, all right, Attorney General Barrett Anderson, thank you very much, you've done that, but what's to assure it's not going to fall backwards? And what's to assure everything else? I don't want to add more to this. The bill talks about if we agree to more, to let the senators know within 20 days. I don't want to agree to any more. I want to just do this order. And whatever needs to be done elsewhere, that's the work of the Blue Ribbon Commission, and then that's the work of the master plan. And I'd like to be able to suggest to Judge Munson that, don't worry, Judge Munson, there is a master plan. There is work beyond that. It's no guarantee the judge is going to say, fine, I'll let you go. Maybe the federal court likes us so much after 20 years they don't want to let us go. But I will make my best pitch. I've entered my appearance in the case along with Assistant Attorney General Kathy Focus. I had to laugh because I said, hold on, I don't know if I'm admitted to the District Court of Guam. It's been so long. But I did find my 1980 admission. And so I will be speaking on behalf of the territory at all the hearings that come up before Judge Munson in the federal courts. With that, Senators, I'd like to turn it over to the Director for his testimony.
Before I have the Director speak,
Yes.
maybe I should have done a couple of things. One, I should have recognized my colleagues that are here. Senator Nicholas to my right, Senator Uggan, Senator Tony Atta, and Senator Tommy Morrison. And I probably should have said something about the bill. Some may say it was prematurely introduced, but what I wanted to do was I wanted to have in the legislative hopper a bill that we could add to and get through as soon as possible. My colleagues haven't had a chance to review the order, but we have to do this within 270 days. And to try to get something through this legislature sometimes can take more than 270 days. And so what I wanted to do was to have a placeholder. I wanted a bill with a number that was in there with an amount that with the understanding that the amount could go up to whatever number the committee, the working group is able to justify that we should appropriate for. And also I advised the working group that in the most recent budget that was passed, we have a public safety vacancy pool of about $6 million. And all the agencies have the authority to be able to use that money with the governor's authorization to hire whatever they need or whoever they need to be able to assure the public safety of the community. And what can't be covered in that public safety vacancy pool will be covered by this bill for any other authorizations or any other appropriations that you feel or the working group feels is necessary to comply with the order. Because like the General said, it is my intention of making sure that we do everything that we can so that she can go to Judge Munson and convince him that we've done everything possibly that we could do to avert any receivership. And I also wanted the first report to go to the legislature. The last section of this has a provision that says, the electronic system. The court further orders the territory of Guam to secure funding to complete the repairs. And it says, Director of DOC in preparing the presentations to request for funding to the DOC, U.S. Department of Interior and the Guam Legislature. I wanted the Director in the first report that goes to Judge Munson later on this month, to say that there's already a bill, that he has testified in favor of a bill to provide the funding necessary for the repairs of the electronic system, because I want him to be able to say that he's trying to comply within the 270 days. And so I understand that this bill is not all that it can and should be, but it is the skeleton, and we just need to put the meat on it and make it beautiful so that we can present it to Judge Munson. That's all. This is just the skeleton, and you all add to it. But
It's a great skeleton, Senator. It's a great
so I just want to thank General and Mr. St. Augustine, because he has been way ahead of this, actually. Every time we've met, I've noticed. I mean, he was the first one at the first tour that said the issue was we need, in order for DOC to fulfill its mission of corrections, it needed to be able to divest itself of its detention obligations. And then when he spoke about the fact that he made some building up there, he couldn't find a master plan. And that's when I said he knows he needs to have a strategic master plan on what he needs to have up there. And so we're all here to support you, Mr. Director, and I've been impressed by the fact that you have a very good understanding of what your responsibilities and your mission is. I may have questioned it in the past, but you understood it. Unfortunately, we just need to get other people to see what we see and to be able to come forward to be able to say, you need that additional personnel. I want to commend you on filling the vacancies of the guards over the last several months. I think we're now fully manned, and there are some female guards that were hired. I saw the graduation. There was about 4 of them. And so I'm just saying we're moving in the right direction, and I just want to assure the director that he has at least my support in trying to meet the obligations, and you, General, to be able for the two of you to be able to go back into district court and say, we have done 6 of the 35, we'll have 12 by next month, and we'll have 18 and then we'll have all 35 done in 270 days. And so this is just the first of many. I know the Lieutenant Governor asked yesterday if we could just get this through in the upcoming session, and as a start, and then we can introduce other legislation later. But I just wanted the court to know that the director and the general have come to the legislature and sought the legislature's assistance to comply with this court order. And so we're having this hearing. It's the first hearing of this committee, and it'll be the first bill that this committee reports out. So, Mr. Director, if you wish.
Yes, Mr. Vice
turn on
Speaker. It is on. Mr. Vice Speaker, thank you very much. I really think the Madam General had covered a large portion of the court order. I do have this afternoon with me a written statement and also an oral statement that I would like to make, if you will allow me. Saluda, Zanafade Vice Speaker, Chairman Benjamin B.F. Cruz, and members of the Committee on Appropriation and Adjudication. I am Joe San Augustine, Director of the Department of Correction, and I am here to provide support for Bill 22-33, an act to authorize the transfer of sum of $500,000 from the fiscal 2015 appropriation to comply with the United States Court of Guam order dated 16 January 2015 in civil case number 91-00020. In addition, it is requested that the Magalahi Guam be authorized to transfer additional funding necessary to specifically comply with the court order dated 16 January 2015. A Department of Corrections Settlement Agreement Working Group has been established to identify and assess the medical and electronic locking systems within the Department of Correction to determine the needs in order to comply with this court order. When the assessment is completed, we will then be able to better approximate the cost and budgetary plan can be then completed per your request. This afternoon, I do not have that budgetary plan as you requested for me to provide, and the reason behind that, as Madam General stated, we need more time to do more assessment. I will like, before I end my comment, that Senators and Vice Speaker, Mr. Chair, from the very beginning, you've been very supportive of DOC. You had other areas of interest, and that's understandable, but I am glad that you continue to support DOC and its mission. You continue to support the men and women of all employees that work up at DOC. So I always saw that in you. Your actions to allow the governor of Guam to transfer 500,000 is an indicator that you are more than willing to help the Department of Correction and this government get over this settlement agreement that's been on our shoulders for the past 23 years. So I just want to thank you with that. So in closing, I just want to remind you all the mission of the Department of Correction. It's to protect our island community by confining offenders in a controlled environment that is safe, humane, and cost-efficient and secure. Since my tenure as the director, I have diligently, in making do the resource available to the Department of Correction toward accomplishing this mission. The great men and women of the Department of Correction has unselfishly supported me in every possible way toward the accomplishment of this mission. I now come before you, August body, to request your support in the assistance for Bill 22-33, so that together we can move forward and accomplish this mission for the people of Guam. Thank you.
Thank you, Mr. Director. Ms. Hawkins, did you wish to know questions?
Thank you, Mr. Chair. Thank you, Madam General and Director San Agustin, for your testimony. I too have been following very closely how things have been progressing since we last had our tour up at DOC. And one of the things that I'm very, I don't want to say excited about, but I'm really pleased about is that it looks like we have a roadmap that we're going to be able to execute in order to keep us out of receivership. Now, I know that everyone's been talking about receivership, but from my understanding, and I guess I'm asking if you can correct me if I'm wrong, if we comply with this order from the judge, then we will not be in any risk of receivership after we fully comply.
The order doesn't necessarily say that, but if you go back to the original judgment, the original settlement agreement, the original 1991 agreement indicated that were DOC to comply with everything and the monitor agrees that compliance has been had, then the government of Guam could motion to dissolve the order and thereby dismiss the case. 20 years later, 90% of that 91 order has been complied with. It dealt with sprinkler systems. It dealt with fire retardant mattresses. It dealt with backup generators. It dealt with rodent infestation. So 90% of that order, the one portion in the 91 order we weren't able to get through, or we had times when we were and then times where we were not in compliance, is the medical and the health issues. And there was a period of time for 14 years that the Department of Corrections did have a physician on board. We were perhaps asleep at the wheel. Why didn't we not go to the judge at that time and ask to dissolve? I have to believe in 20 years we had come to a point of full compliance. Today we're not. It is my hope that Judge Munson, going back to the original order, agrees that once we have fully complied, and he's satisfied that the items here are fully complied with, and the monitor agrees, and I really don't want to add more to this. That'll be in the master plan, that I will request Judge Munson to dismiss this. I can't guarantee the judge will, but I will make my strongest argument. And the arguments that add to this are things such as this legislation, which will be included in the first report to the judge that Assistant Attorney General Focus will present to the court. It will be in the monitor's report as well. So, when you see good faith and substantial compliance from the government of Guam, I hope the judge sees there will be good faith and substantial compliance without having to be under the gun.
Okay. What I'm really looking for is a clear understanding of what we need in order to be compliant versus the conversation that we've been also having about building a new facility, and whether or not compliance and the prevention of receivership is synonymous with a new facility. Because from my understanding with respect to this order and the testimony that we've had, to step away and make receivership no longer an issue means we simply comply with the judge's orders.
We have two issues here. One is what faces the legislature overall, and as the Vice Speaker said, we have to move away from being a prison detention into corrections, and that is not an issue in this order. This order is finite. It has items, 35 items here, and it is a roadmap. And that is the distinction between the working group and the Blue Ribbon Commission. The Blue Ribbon Commission goes beyond that, Senator, and I am not necessarily a part of that. This working group is clear, it's finite, and I'm dead set on trying to accomplish as much. Does that help you understand?
Crystal clear. Crystal clear.
This one's receivership. The other one is
other stuff. Crystal clear. So, and so just so I fully understand also, with respect to the bill from the Vice Speaker, the funding that we're talking about here is pretty much, I always use business terms, it's seed money to get us to complete this roadmap. And as we identify the other financial needs that come up in order for us to fully complete the journey of this roadmap, we can go ahead and just keep amending the bill to add more funds on top of it, so that we can meet the deadline while also opening up the cash streams right away.
And that's the working group's objective for the legislature. We need to inform not only the governor but the legislature where we are. Is 500,000 enough? You need some figure. So you need a working group to be able to give you those kinds of details. Okay. So that's what this group is about.
Okay. I fully support a compliant prison, and so I look forward to doing whatever I can to help the Vice Speaker's bill along. Thank you very much.
Thank you very much, Mr. Vice Speaker, Mr. Chairman, and General Barrett Anderson and Mr. Snogstein. Thank you for your testimony this afternoon and all your ongoing efforts in terms of trying to resolve this particular stipulation. And, Your Honor, I'm truly appreciative of the focus that you've placed in terms of addressing the 35 items highlighted by the district court. And I say that primarily because with the focus being placed on these items within the constricted time frame of 270 days, hopefully these issues will be set aside after the activities of this particular government. I think my question would be, there's a piece of legislation before us that would provide budgetary flexibility in case Department of Corrections is in need of additional resources. But I'm looking at the GSA component. I know GSA sits at the table, the working group. They're providing as much assistance as possible, but within the legal means, is there a need to provide that additional flexibility within the next 270 days to support the working group in your efforts in terms of expediting some of these procurement services, contracts, or supplies and equipment?
I believe that the current procurement laws are sufficient. And under one of those laws, if there is anything within the working group's purview that goes over $500,000, the Attorney General's office is right there to make sure that procurement is properly bid out. So we have that. But Senator, if there is anything that crops up that we see an impediment, this working group, we're going to get that straight down to you as quickly as possible.
Please, if you can, because I know that you're very familiar with the procurement process, and obviously there's that authorization aside from the use of the governor's emergency procurement authority. I believe that's capped at either 250 or 500,000. Now, anything that would exceed that, and you would need quicker responses aside from the 60 days or 90-day stipulation, then certainly the legislature stands ready to, or at least the chairman, I would like to speak on behalf of my chairman, certainly stands ready by virtue of the introduction of this legislation to be able to ensure that that particular aspect is incorporated in here, because providing the budgetary flexibility is one thing, but if by any chance you don't have that legal authorization, and we have General Barrett Anderson here to ensure that the laws are followed, then certainly we don't want to be coming back at a second step when in fact we could address it here. So I appreciate your response, and I certainly look forward to the continual collaboration, and in 261 days, perhaps getting a reprieve.
Just to let you know, the clock doesn't begin to tick until February 16th. So we
also
are
30 days from the date of the judgment.
We are ahead of ourselves, yes.
Okay. Thank you very much. Appreciate it.
Thank you.
Thank you, Mr. Chairman.
Well, no, I don't believe any of them wanted. Well, thank you very much. Keep up the great work, Director. In general, I think you're staying for the next bill.
Yes, I am.
Okay.
The next one. Thank
All
you
right.
very much.
Thank you.
Thank you.
The next bill is Bill 30-33, again introduced by myself. It's an act to amend Section 30102 of Chapter 30, Title 5, Guam Code annotated to require agencies permitted to retain counsel other than the Attorney General to hire classified in-house counsel. This bill was introduced last year and it was passed. Unfortunately, it was vetoed. The intent of the legislation was to get the autonomous agencies and the other line agencies that have the authority to hire legal counsel to hire in-house counsel so that they're able to do it within a set amount of money as opposed to $300 an hour and asking PUC for the authority to sign contracts for legal services in excess of $1 million, or running up a couple of the agencies getting really close to $1 million in annual attorney's fees. It would seem to me, when I introduced the legislation, that the perfect example would have been the university, GWA and GPA that have in-house counsel. They pay theirs $120, I believe, or $115, depending. They do all the civil service stuff. They do all the minutes for the board meetings, and it's not at $300 an hour. And so that was the intent of the legislation. I'd be interested to hear what the new general's position is on this piece of legislation.
Good afternoon again, Mr. Vice Speaker and Chairman and members of the committee. I'd like to introduce to my right is Deputy Attorney General Carl Espaldon. Carl is now Deputy of the Solicitor Division. The Solicitor Division is a division made up of Assistant Attorney Generals whose primary focus is to advise and counsel agencies. During my earlier tenure as Attorney General, we had a solicitor division and a litigation division, both civil. Litigation, obviously, got a lawsuit, you go into court. Solicitors, opinion writing, advice on a daily basis. And the two divisions were kept separate. Since I left and I come back to the Attorney Generals, and the first thing I immediately did was to break them apart, because their function and focus is absolutely different. And I am in the process now of rebuilding the solicitor division. And that's important for me as to let you know initially before I extend my testimony, because this bill directly impacts the work that we do for our agencies within the solicitor division, okay? The legal in-house counsel. Vice Speaker, I support cutting costs. I always have. And even as the former Attorney General, we had a solicitor division of about 12 attorneys representing all line agencies. We had also particular solicitors paid 100% to GIPA and other agencies that wanted their full-time, but we didn't have the money for it. I said, you want a solicitor? I'll hire and we'll assign out. The purpose of having that type of governmental cognizance and control is so that government of Guam agencies, whether line or autonomous, but predominantly the line agencies, so that there is consistency in the types of opinions, the types of legal services that are given out there, predominantly in the line agencies. During my tenure with regard to the autonomous agencies, the issue of retainer agreements for autonomous agencies has historically been there. And the legislature has historically fought, as the Attorney General's office has fought, to try and rein that in and to rein in the enormous costs. I do appreciate and recognize that autonomous agencies do need specialized counsel in areas of maritime, health, aviation. And during my tenure, we actually had a very good working arrangement with a lot of the law firms that if it came to issues of personnel, adverse action, procurement, typical legal issues involving the government of Guam, the firms would say, hey, just go ask the AG for that. You know, we're not going to charge you for that. The AG has the expertise. That doesn't seem to be the case these days, and now, I'm revisiting so many issues that are deja vu from my tenure before. One of the differences in coming back are that all attorneys who work full-time in the government of Guam, and when I say full-time, I mean they earn benefits, they earn retirement. They must be classified because of the Hauser versus Department of Law decision. No problem with that. All the lawyers in my office, other than the management attorneys, all the assistant AGs are classified. We hire under the classified system. So the recommendation in the bill, and this was discussed the last time the bill was before the legislature, we do support that, classified attorneys. I agree with the Vice Speaker wholeheartedly. You can get a very experienced attorney for about $120,000 or a little less. That's good money these days for an in-house counsel. No problem that it's classified. My one concern with government, let's say the line agencies or even the autonomous agencies, hiring in-house is that extra 10% that I cannot give the solicitor attorneys. And so I do know that if this bill does pass, line agencies who are authorized to hire their own lawyer, like the Guam Department of Education, not quite sure what other agencies currently are authorized, will turn to the ranks of the assistant attorney generals in my office who have the experience in the issues of procurement and personnel, etc., and offer them that 10%, and I will lose them. I would like to see a process of what I recommended previously, that if agencies do want to hire in-house counsel, that the Attorney General's office provide the in-house counsel through a not cost sharing, but a service agreement with the Attorney General's office. We will then hire, send out to, whether it's a Guam Memorial Hospital or DOA or whoever, will be under the purview of the Attorney General's office for consistency, and also comports with my requirement as Attorney General to have cognizance over all legal matters. So we have consistency in opinions, consistency in our interpretation of procurement and personnel laws. With regard to autonomous agencies, we could still do the same thing as we do with line agencies. If the Guam Power Authority, well, they actually have their in-house counsel, which is fine. But the Attorney General's office has no cognizance over what that in-house counsel does. And I don't even know who the person is. The cost is great. I would like to see that any opinion issued by an in-house counsel that is not under the charge of the Attorney General's office, that I be able to review opinions issued. Not daily things, but just opinions, in the event I disagree with the opinion of a totally independent in-house counsel. Regarding retainer agreements, that's been around forever, and I understand, I recognize those retainer agreements, but I agree with the speaker that those agreements can be limited to the areas of and the fields of law that my office has no expertise in. But we have a lot of expertise on the basics, procurement, personnel. There was land issues. Oh my goodness, the Office of the Attorney General is very good with land issues. Easements, So in those areas, I fully support the speaker's intent to reduce those kinds of costs in those areas. In doing so, however, I will be down here in a couple of months for a budget request, and I ask the senators to please give me your support to rebuild the Solicitor Division. I would love to go up to 12 attorneys for all line agencies, and that includes the legislature if you request for an opinion. That includes the courts if the courts want an opinion. The Solicitor Division really, in a lot of ways, is the core of daily legal operations of our government. I do recognize one thing, senators. I have walked back into that office after 20 years, and I have heard every government agency complain. Well, it takes so long to get anything out of the Attorney General's office. I recognize that, and I intend to correct it. This is only day 23. But with rebuilding the Solicitor Division, contracts should have a return time on an average of 10 days if they're the standard contract. If they have a little bit more issues on that, maybe 30 days. An opinion, maybe 60 days or less than that. But what I've heard from a lot of directors and members of the government agencies, it just takes so long at the Attorney General's. Why does it take so long over there? What's happening over there? I don't know. But with Deputy Attorney General Carl Espaldon and rebuilding the Solicitor Division, I hope to correct that. And with that, Senators, I welcome any questions.
Thank you very much, and I appreciate your comments, and I really would like to sit down with you to see how we can do this, because I would like to go back to the old system. I know everybody keeps laughing at me. I was born in government system in 1970, and I keep saying, when did it change? And but I'd like to be able to go back to that, where the solicitors provides all the, but we're going to need to find you the additional money and see if we can get some of those agencies to help out. But as you put it, the complaint is it takes too long to get anything out of there, and so that's why they want their own. And but their own shouldn't cost them $1 million a year. And so if we can somehow work on this, I know your hands are full with that blue binder that's next to you, but maybe, well, spend 15 minutes to try to figure out a different way of getting this bill to meet my expectations and also your desire to rebuild the solicitor's office.
Yes, Senator, when I first saw this law, I was informed that the Attorney General's office can now charge agencies and line agencies for services, and I thought that a little strange because the line agencies are our client. You, the legislature, you give the Attorney General's office money because we are the counsel for the line agencies. So, Mr. Vice Speaker, I would love to take that paragraph A and to work with you to return it to the old ways and to be able to provide all agencies the expertise that they deserve, whether they're line agency or not. And I know we can do that, and don't worry about the blue binder. This is close to the work of the Attorney General's. It's a core of the Attorney General's office. And I knew about it before I walked in. It was on my radar screen, and your bill has just put it to the top of the radar screen to work with you on it.
Okay. No, I'm not going to rush it through. We'll have time to sit down with you and Carl to see how we can do this. And hopefully this time the governor will buy it. But I'd like to be able to see the Attorney General's office back to being the Attorney General's office of Guam.
Thank you so much. Thank you.
Okay. And congratulations, Carl. Welcome home. It's about time. Thank you. With that, all the bills would have been heard. All comments will be received for the next 10 days at senator@senatorbjcruz.com or 477-2522 by fax, or you can drop it off at 155 Hessler Place at the mail room, and it'll be delivered to my office. Again, thank you, and we stand adjourned.